us. This is Helping Sexual Assault Victims Navigate the Criminal Justice System, Effective Use of a Multidisciplinary Approach. This presentation is supported by an OVW grant, the Office on Violence Against Women, and the concept of encouraging multidisciplinary approaches to the criminal justice system, especially in the context of sexual assault, is the inspiration for our development of a larger project, which I'll describe in a moment. If you have any questions during the presentation, as Patricia said, just put them in the Q&A box on your screen, and please include your email address. If we don't have time to address your questions during this presentation, I will be sure to respond by email after the webinar. I'll also just make a quick note about my use of language today. I'll primarily use the word victim during this presentation, and that's because victim is the language of the criminal justice system, and it's the word used in most criminal statutes and victims' rights laws. Depending on your discipline, you may think of folks as clients or patients. And of course, I in no way seek to minimize any other language that empowers, like the use of the word survivor. So Legal Momentum is a nonpartisan, nonprofit 501c3 organization. We were founded in 1970, and we're the nation's oldest legal advocacy organization dedicated to advancing the rights of women and girls. And gender-based violence has been a particular focus since our inception. So we know that the criminal justice system can be mystifying and intimidating for those who are outside of its inner workings. And understanding that, we're currently developing what we call Helping Sexual Assault Victims Navigate the Criminal Justice System as an online training tool and a supplemental state-specific guide template, with the hopes that it will empower victim advocates to take a meaningful role in the criminal justice system. It will provide an overview of the criminal justice system and the intersecting laws and processes. So it's our intention that with this knowledge, victim advocates can better serve their clients who are navigating the criminal justice system or considering it. This program is under development, and this presentation is meant to encourage and assist you in developing community relationships to help your clients navigate the criminal justice system in the meantime. So I just would like to get a sense of who's participating today. We're going to open a poll to see which disciplines are represented. So when the poll pops up for you, just select which discipline you fall into. Okay, I think we can close the poll. Oh. Okay, I think we can close the poll now. And let's see. It looks like at most more than half are victim advocates, and a good percentage are other and victims attorneys, with a little bit of law enforcement and prosecutors. Okay, great. And so then I just want to get a sense for within your discipline, who has worked with a victim of sexual assault? Okay, I think we can end the poll. Looks like, oh no, not yet. Okay, I think we can close it. It looks like the responses are tapering off. So most people have worked with victims of sexual assault in their discipline. Okay. So for the victim advocates who are participating today, how confident do you feel in your knowledge of the criminal justice system, whether that's overall or in your locality? Okay. All right, it looks like most responses are in. I think we can close the poll. It looks like more than half are in the somewhat confident, and that's typically the response I get when I ask this question about More than half tend to be in the somewhat confident. So for the victim advocates, again, how many of you feel that you've been able to play an important role in the criminal justice process on the behalf of a sexual assault victim? We'll open that poll. Oh, sorry. So if you can just raise your hand on this one then. Raise your hand if you feel that you've been able to play an important role in the criminal justice process on behalf of the sexual assault victim. Okay, great. Thanks. Okay, and then we had only a few participants who identified as law enforcement prosecution, but for those attendees, how many of you feel like you have a relationship with community-based advocates in your community? You can just use the hand-raising feature. Okay, thanks. All right, and then the last question is, regardless of the discipline that you work within, how many of you are participants in members of a SART, which means Sexual Assault Response Team in your community? And you can, again, just use the yes-no poll. Okay, why don't we go ahead and close that? Seem to be trickling off. Okay, so more than half. Great. All right, so let's start with sort of the 30,000-foot view, the landscape in the United States, just to remind ourselves of the context that we're all working in, regardless of our discipline. Dr. Kilpatrick and his team at the Medical University of South Carolina, they're among the most highly regarded researchers in this field. Some of their findings are on the slide now. Dr. Kilpatrick's study, quoted on the screen, estimated that in 2006, women over 18 were subjected to more than 1 million rapes, over 800,000 of which were forcible. Nearly 200,000 were facilitated by drugs, and about 300,000 where the victim was incapacitated. So let's view that in the light of data that's been collected by the FBI through the Uniform Crime Reporting System, to which about 18,000 law enforcement agencies throughout the country contribute data. Their data from 2015 shows that approximately 214,232 rapes were reported to law enforcement. Now, with the caveat that they use a limited definition of rape. And of those 214,000 and change, 22,863 resulted in an arrest. That's approximately 10.5%. So given that we know sexual assault is greatly underreported, and comparing Dr. Kilpatrick's findings on prevalence, in reality, that percentage is likely much lower. So the big picture is that few sexual assaults are being reported, and even fewer result in arrest, prosecution, and conviction. There are many reasons why sexual assault victims don't report the crime to law enforcement. Many of those reasons have to do with the system itself, and I recognize this having been part of that system for a number of years. Of the victims that do report sexual assault and whose perpetrators are actually arrested, there are many reasons why that arrest doesn't result in a prosecution or a conviction. And one of those reasons is victim attrition, meaning that the victim stops cooperating with the prosecution or law enforcement somewhere along the way. Again, this is often because of the system itself. It can be long, drawn out, and can generally make the victim feel like an outsider to their own victimization. But it doesn't have to go on this way. There's plenty of room for improvement, and we can improve in ways that still protects everyone's rights. So I want you to take a moment to think about the phrase victim-centered approach. A victim-centered approach by the criminal justice system is an important factor in sexual assault victims being able to access justice. So just take a moment and think about, in the context of sexual assault in the criminal justice system, what does this phrase mean to you? What do you conjure up for a visual for yourself? So what I think of is something that looks a little bit like this. Many community institutions and agencies looking inward toward the victim for insight on how to best fulfill their individual roles. So the criminal justice system's protections generally center around a criminal defendant's rights. And with the defendant's liberty and sometimes life at stake, that's understandably so. We're getting a bit better now at understanding that a sexual assault prosecution can preserve a defendant's rights while at the same time being trauma-informed and victim-centered. But how we do this effectively is still emerging. So the point of today's presentation is to show you that in order for the criminal justice process to truly be trauma-informed and victim-centered and achieve justice for everyone involved in the system, community partnerships are key. And I'll come back to this point, but we have to remember that we can't be experts in everything, but we can't also just operate in our own silos if we're really to achieve justice for our clients who are victims of sexual assault. So later in the presentation, I will speak about some specific ways that different professionals in our communities can assist the criminal justice system in meaningful ways to achieve justice. But I'm going to start us off with just a few illustrations of what I mean when I say this. So, for example, victim advocacy groups can build relationships with other advocacy groups, like, for example, disability advocacy groups in your community. You can train one another. You can share resources because you each have an expertise, and you can have relationships to refer clients to one another to sort of bridge the gap and make sure that all services are being provided. When law enforcement and prosecution engages with advocates, advocates can do things like help set the pace during interviews with victims to have, in a way that best helps the victim understand what's going on, can help identify when the victim is having difficulty understanding a word or a concept that's being discussed in interviews or conversations about the process. Because the criminal justice system really has a language all its own. And when you're fluent in that language, sometimes you fail to recognize that you're not relaying the information in a digestible manner. And I've certainly been there myself. And advocates can help law enforcement and prosecution frame questions and can help the victim frame their questions so that law enforcement and prosecution understands where the knowledge gap is and can help them better understand the process. Disability advocates can help ensure that all of the processes are accessible for each individual. Law enforcement and prosecution can help advocates understand the criminal justice process so that the advocates in turn can help the victim stay apprised of each stage of the process as it's happening. Those are just a couple examples, and we'll go into them as the presentation moves along. But let's just first ask ourselves the question, why should the criminal justice system be victim-centered? Because it's the criminal defendant's rights who are implicated, right? Well, Justice Cardozo's quote on the slide now from 1934 reminds us that victims' rights are implicated in this process too. When he wrote, "Justice, though due to the accused, is due to the accuser also. The concept of fairness must not be strained till it is narrowed to a filament. We are to keep the balance true." We have to remember and remind the criminal justice system that victims don't choose to enter the criminal justice system, and they have rights implicated too. A couple of examples: their right to reasonable protection and their right to privacy. And that victims suffer significantly in a multitude of ways in the aftermath of a sexual assault. So we'll next discuss the impact of sexual assault on a broad level and victims' rights implicated. So we know that observable physical injuries from a sexual assault are the exception rather than the rule. And Dr. Kilpatrick's work from 2007 revealed that 70% of drug-facilitated and incapacitated rape victims and 48% of forcible rape victims reported no physical injuries at all. So that the majority of sexual assault victims will have no observable physical injuries has allowed the myth to perpetuate that rape victims suffer no serious harm. But we that do this work know that couldn't be less true. No two victims suffer in the same way, but we know that sexual assault can affect every facet of a victim's life. So we'll just, on a broad level, explore some of those harms. When we talk about psychological harm, I'm sure that from each of our work we all have anecdotes and have seen firsthand the tremendous effect that sexual assault has had on a victim. A couple of studies just to highlight this impact. One study of 95 female rape victims found that 94% met the symptomatic criteria for PTSD, post-traumatic stress disorder, shortly after the sexual assault, and 47% still met that criteria more than 3 months later. And among those who still met the symptomatic criteria more than 3 months after the assault saw little improvement over time. Other studies have shown that trauma from sexual abuse is associated with more severe post-traumatic stress disorder symptoms than trauma from motor vehicle accidents or the sudden and unexpected death of a loved one. And yet another study among rape victims found that rape victims were 4.1 times more likely to contemplate suicide than non-crime victims and 13 times more likely to attempt suicide than non-crime victims. And we know that victims suffer financial harms, things like lost wages, moving costs, unreimbursed medical expenses. For victims who are students, they can suffer lost scholarships, financial aid implications if their victimization results in their not being able to continue with school. And although I mentioned most rape victims will not suffer serious physical injuries, it has been found that 6% of drug-facilitated and incapacitated and 16% of forcible rape victims do suffer serious physical injuries, which will have medical implications. And some rape victims will experience things like unwanted pregnancies or contract sexually transmitted infections, all which will require continuing medical care. And of course, we have to acknowledge the physical safety concerns. Given that most sexual assaults are perpetrated by someone who's known to the victim, a sexual assault victim may need to take precautions like obtaining an order of protection, changing their locks, their phone number, taking precautions in changing the commute that they take to work, maybe even relocating entirely. So what rights do sexual assault victims have? Well, on the federal level, there is no federal constitutional amendment granting crime victims with rights. But there is federal legislation, the Crime Victims' Rights Act, enacted in 2004, which provides rights for victims in federal criminal proceedings. And this legislation grants victims specific rights, some of which are right to be reasonably protected from the accused, the right to reasonable, accurate, and timely notice of public court proceedings, not to be excluded from any such court proceedings. And of course, there are exceptions to these rights. The right to be heard at proceedings involving release, plea, sentencing, or parole. The right to full and timely restitution, to proceedings free from unreasonable delay, to be treated with fairness and respect for the victim's dignity and privacy, and the right to be informed of their rights. Because, of course, if a victim's uninformed of their rights, they are limited in their ability to ensure that they're receiving all the rights they're due. On the state level, every state has at least some statutory protection for crime victims. So an example of that might be a statutory provision giving crime victims the right to receive restitution in certain circumstances. And to date, 33 states, the ones that you see on the slide currently, have amendments to their state constitutions that guarantee crime victims at least some rights. They vary in their protections. Some grant the right to be informed and present at the proceedings, and then leave to the state legislator to create implementing statutes that bestow more specific rights under the constitutional amendment. Or other states' constitutional amendments provide more specific rights within the amendment itself. No matter what discipline you work in, if you work with victims of crime, any crime, you should be aware of what protection your jurisdiction affords to crime victims. We'll take a look at just a couple examples. So the Colorado Constitutional Amendment granting crime victims' rights was enacted in the early 1990s, and this is an example of a pretty general approach. The language of the amendment itself, in pertinent part, is on the screen and reads, "Any person who is a victim of a criminal act shall have the right to be heard when relevant, informed and present at all critical stages of the criminal justice process." And then the Victims' Rights Act was enacted by Colorado's legislature, and that's the enabling statute which defines what some of the terms within the constitutional amendment actually mean, what rights they actually confer upon crime victims. So this concept of being informed, present, and heard at critical stages is a common one seen throughout victims' rights laws and amendments. And so just the phrase critical stage, what does that mean, right? Well, it's not just the obvious stages of trials and sentencing hearings. The bullets on this screen that you see now show you how the Colorado Victim Rights Act implemented their constitutional amendment, which granted victims the right to be informed, present, and sometimes heard at critical stages. So I'm breaking all PowerPoint rules with this particular slide to show you how many stages that really includes, because it goes well beyond those stages of the criminal justice system that we see wrapped up so neatly in 60 minutes of a Law and Order episode. Each of these is a critical stage at which the victim has the right to be present and informed, every single one of them. And the italicized stages are those which the victim has the added right to be heard. So note that generally a crime victim will have the right to be informed and present at all critical stages, but only have the right to be heard at some. Most commonly, for example, at a sentencing, or to deliver what's referred to as a victim impact statement. You should also be aware that a victim may have an obligation to affirmatively request ongoing notification, either for all stages or at some point in the process. So, for example, under this Colorado statute, for all of the critical stages listed here that happen after the defendant's sentencing, the victim's right to be informed and present is triggered only if the victim provides written notification indicating that he or she wishes to be continually informed. And so when you look at your own jurisdiction's victims' rights law, you should be aware of these caveats. So I'll also just highlight Florida's constitutional amendment as an example because it includes this language to the extent these rights do not interfere with the constitutional rights of the accused. So this language makes quite clear that the defendant's rights trump those of the crime victim. It leaves it open for the court to balance the rights of the accused and the accuser. And that brings me back to Justice Cardozo's quote that I shared with you a few minutes ago. Taking a victim-centered approach to the criminal justice system does not mean infringing on the constitutional rights of the accused that are so important and woven into the fabric of our society. We can strike a balance. Often the justice system, the attorneys, the judges, need reminding of this because they can get quite focused on standing really far back from that line that might infringe on the accused rights. So how do we strike this balance so that the criminal justice system's protections protect the rights of the accused in a trauma-informed, victim-centered way? How do we even start that? Well, the start is coming together. making sure that everyone in our quote-unquote village is an important part of the justice system. And I'll reiterate again that we can't be experts in everything, and we shouldn't try, but we can't also just stick to our own corners if we're to ensure that the victims that we work with have meaningful access to justice in our communities. So, as I said before, community partnerships are key to making the criminal justice system a place where justice is found and ensuring that the justice system itself is not contributing to any harm. Finding a way to work together will bring swifter justice as well, and in my opinion, it will have derivative benefits. So, for example, community partnerships approach to the criminal justice system will improve community relations with law enforcement, where maybe that has broken down. It may restore faith in the community that the justice system is a place where citizens can and should turn to. Hopefully, this manifests in an increase in the reporting rates of sexual assault so that the justice system has an opportunity to respond. This approach will allow advocates to better serve their clients because advocates will then be able to meaningfully guide their clients through the criminal justice system, either if they're already navigating it or if they're trying to make the decision whether navigating the criminal justice system is the right choice for them. This hopefully leads to more engagement of victims in the system, even when the wheels of justice are turning slowly. But what role can each of us play, you might be asking? Well, first, it's important for those of you who are not law enforcement and prosecutors today to understand or remind yourselves of the very specific role that the prosecutor plays. Because the prosecutor is not the victim's attorney. There's no attorney-client relationship or privilege. Prosecutors are sworn to uphold the law and represent the people of the state, represent the government. And essentially the victim is a witness, albeit an interested one. So for the victim advocates, what can you offer to the criminal justice system to improve its response to sexual assault? Well, as a victim advocate, if you have a good working relationship with the law enforcement and prosecution in your community, and you have a good understanding of the criminal justice system broadly and the local practice in your community, you can help alleviate the burden of keeping victims notified and informed of the process. Prosecutors often carry heavy caseloads, so having an advocate engaged can help ensure that victims know what's going on so that no notification opportunity slips through the cracks, and can help ensure that not only are they receiving that notification, but that they understand it. And advocates can link resources. So I mentioned victim attrition, and there are many reasons why victims begin navigating the criminal justice system and at some point stop wishing to do so. But where a contributing factor is the need for resources, like maybe new housing, public assistance, therapy services, the advocate can help identify those needs and ensure that all those needs are being met. Because if a victim doesn't have his or her basic needs being met, they're really less likely to stay engaged in the criminal justice process. And in a lot of circumstances, advocates are better positioned to identify those needs with a victim and assist him or her in meeting those needs. With community partnership, no matter who realizes the unmet need, advocates can help bridge those services so there's no barrier to the victim navigating the criminal justice system if that's something that they want to do. Advocates can be expert witnesses in sexual assault cases. So because this is a national audience, I'll just default to the federal rules. Every state has enacted their own rules of evidence, but under the federal rules, an expert witness is someone who's qualified by their knowledge, skill, experience, training, or education. And if that specialized knowledge will assist the trier of fact to understand the evidence or determine a fact and issue, then an expert witness can offer evidence and can provide an opinion on an issue. So I highlight this to remind you or to inform you that experts don't need to be doctors or PhDs. You can qualify based on your extensive experience working with victims, working within sexual assault. And victim advocates can be invaluable experts in some circumstances at dispelling many of the myths that are commonly held about sexual assault and how, quote unquote, how a real victim acts. These are myths that are commonly held in the folks that are deciding criminal proceedings on sexual assault, the jury pools. So you can be invaluable in that way. And very simply, advocates can be a friendly face in the courtroom. An advocate who has been working with a victim and has built a rapport can be an immeasurable comfort to a victim who has to appear in court to testify, to deliver a victim impact statement. Just seeing your face can really go a long way at making that really difficult stage of the process a little more bearable. In the advocate therapeutic space, advocates can help victims verbalize their emotion, their trauma, so that they can convey that effectively to law enforcement and prosecutors, who then in turn will more effectively be able to convey the evidence in their case, the impact that the sexual assault has had on the victim. And advocates can help identify civil legal needs of victims. So one of the goals with the online training that we're developing and the supplemental guide is to help advocates identify, as you're working with victims, when a sexual assault victim may need their own legal representation. So just to give one small example, a victim may need their own legal advocate when an issue pertaining to their privacy comes up related to the criminal proceeding. So for example, if, say, the defense attorney is requesting access to the victim's mental health records, it may be that the prosecution is not, or under the law they cannot, sufficiently assert the victim's privacy rights. Advocates, if you're a part of the system, engaged in the process, can help build relationships also with community pro bono attorneys or legal advocacy organizations like Legal Aid or nonprofits that represent domestic violence victims, for example, in your community. And then help the victim by identifying when they may need to consult with their own legal counsel. So our forthcoming supplemental guide will expand on ways you can develop these relationships in your own communities. So sexual assault nurse examiners or forensic examiners, how can they play a meaningful part in the criminal justice system? Well, they are not an arm of the law. They are independent medical providers. For those of you who aren't familiar, these are the medical professionals who conduct sexual assault medical forensic examinations, what's colloquially known as collecting rape kits. Most often, their contact with a sexual assault victim is within hours of the victim's outcry of the sexual assault. The SANEs that I worked with as a prosecutor were by far the most compassionate providers I've ever known. They had an amazing ability to build a rapport with sexual assault victims and make them comfortable in a very short period of time and in an incredibly uncomfortable process. And that gave them just an immense amount of credibility in the victim's eyes. So when SANEs or SAFEs have a relationship with the law enforcement and prosecution in their communities who handle sexual assault cases, which is definitely easier in a smaller community, the SANE can impart to the victim that they're familiar with the process, they're familiar with the professionals who the victim's likely to engage with as the process continues, and thereby the SANE or the SAFE is starting the rapport building before the victim ever meets law enforcement or the prosecution. And later, as the case progresses, a SANE or a SAFE may recall details about the victim's appearance, demeanor, statements in the paperwork don't reflect, or that the victim, him or herself, doesn't recall. Because at the time of these exams, a victim may be in a state of shock, may have blocked out that experience for self-preservation. And because these professionals have no skin in the game, no stake in the outcome, they can provide a neutral perspective on what they observed about the victim in a critical time frame after the assault. For that reason, they make powerful expert witnesses that juries tend to respond very well to. And as expert witnesses, they can help juries put evidence in context, things like a lack of observable physical injury, or help dispel what's referred to as the CSI effect, which is a term you may have heard, and basically refers to the expectation many people have formed as a result of shows like CSI that in any quote-unquote true allegation of sexual assault, there will be some forensic evidence like DNA or fingerprints that identify the perpetrator or confirm that the sexual act was not consensual. And these professionals can be available to both the prosecution or defense, which is a fact that makes juries really comfortable with their account also. And for those of you who might not be as familiar with the process of these examinations, I'll just note, and we'll expand on this in our forthcoming training, but these exams can't prove anything on their own, but they are really helpful pieces of evidence that frame the victim's narrative in a sexual assault case. And for the law enforcement and prosecution, if you don't have relationships with the SANE or SAFEs in your community, from my experience, it doesn't matter how many sexual assault cases you've investigated or tried, because you're not a medical professional, you're just not tasked with staying up to date on medical developments, et cetera. And consulting with a SANE or a SAFE during preparation of your case or your investigation, whether or not they were the treating professional in the case, can help you see your evidence in a light you hadn't considered previously. And it also can allow you to develop alternative ways to present your evidence or preempt attacks on your evidence by the other side that you hadn't anticipated might be an issue. So psychologists and social workers can also be really valuable to the criminal justice process in the context of sexual assault. Law enforcement and prosecutions can develop relationships with local psychologists, with social workers that can provide them information generally, or they may be treating professionals of victims. They can be community-based, they might be school-based. As an expert witness, they can provide really valuable information to juries to help them put other evidence in context. So, for example, if this is relevant in a case, a psychologist, a social worker qualified as an expert may be able to explain what's known about the dynamics of relationships where domestic violence or sexual violence is perpetrated, so that they can help put, for example, a delayed report in context where there's a long gap in time between the perpetration and the report to law enforcement. They can, if relevant, explain the neurobiology of trauma, which can explain why certain victim behaviors may seem contradictory to those who aren't familiar with the dynamics of sexual assault. So things like why a victim may present at trial with a flat affect, or why a victim didn't put up physical resistance during an assault. They can help in many ways law enforcement and prosecutors understand conditions or disabilities or aspects of trauma faced by the victim. So I'll give you an example from my days as a prosecutor. I prosecuted a case of a sexual assault victim who had learning disabilities and developmental disabilities. She was an adolescent, and she became confused during our interviews. I wasn't the initial prosecutor on the case, and at the time that I met her and tried to flesh out the details, the facts of the sexual assault, it was apparent that she was very confused during the interviews, and she had trouble really fleshing out the details and distinguishing between vaginal or anal penetration, which was relevant to the case, had difficulty telling a linear story or following a line of questioning, seeking to develop a linear story. So after getting permission from her parent, I was able to speak to her school-based psychologist who had a relationship with her and was familiar with her diagnoses. And she was able to provide me information about her disability, how she learns best, how she communicates best. She was able to help me develop questions and phrases that were not likely to confuse her and help me identify those types of questions that were likely to confuse her. And so after those conversations, my interviews with this victim drastically improved. And from those improved communication, I realized that, in fact, we had charged and indicted the defendant with the wrong conduct. And in the state, under the state laws where I practiced, it meant that the charges we had brought against him, I could not prove at trial, and the only charges that I could prove, he was never charged with. So fortunately, because I learned to effectively communicate with her before it was too late, I was able to amend the charges, and he was able to be prosecuted under charges that we knew we ultimately could prove. And so, related to that, psychologists and social workers can help law enforcement and the prosecution evaluate the evidence that they have and can help explain stages of a victim's healing, like I said, things like a victim's disability. And I'll note here, though we won't speak too specifically about working with sexual assault victims with disabilities in this presentation, that just because a victim has a disability, it doesn't mean that he or she is incapable of consenting to sexual acts. And so as law enforcement and prosecution is evaluating evidence in cases where the victim does experience a disability, psychologists and social workers can really help prosecution and law enforcement understand the individual victim so that they're pursuing the right charges and the right theories of their case. And as the anecdote that I told you illustrates, psychologists and social workers can be really meaningfully involved in helping law enforcement or prosecutors prepare for upcoming stages of the criminal justice system, like testimony, or helping a victim develop their victim impact statement, or helping a victim understand the parameters of a negotiated plea agreement so that they understand what's about to happen in the case. When, for example, you have adolescent victims who are in school and you have a relationship with school-based professionals, they can help on their end by ensuring that there are no barriers in school that are setting the victim up for more negative consequences, like having teachers reschedule tests or giving extensions on papers, something so some measure taken so that upcoming proceedings in the criminal justice system aren't impacting other aspects of the victim's life. So another example from my experience as a prosecutor, again, a sexual assault of an adolescent victim who was victimized by her biological father. And she was meaningfully engaged in therapy from the time that she first disclosed the abuse. And at some point in the process, her and her guardian granted me permission to speak to the therapist, and we developed a good working relationship. I kept the therapist informed of the progress of the case, and in turn, she took that information and structured her therapy with the victim based on the upcoming proceedings. So when we approached a definitive trial date, she began to work with the victim specifically on developing a narrative, as that hadn't been part of her previous therapy, and something that she was really struggling with, putting words to her trauma, and to work with her about other specific fears about what it means to testify. And we learned from each other. It was really a give-and-take relationship. Generally, when we began communicating with each other, the therapist had relayed to me that she had been under the impression that a trial date meant trial would begin. And she had no idea about the lengthy process in our local practice where we both worked, and the fact that there was inevitably delays in a case. So I was able to help her understand local practice and the criminal law where we both worked, so that as she worked with not just the victim we were communicating about, but other clients of hers who were involved in the criminal justice system, she had more reasonable expectations about how the process moved along, and therefore could prepare them and help them work through what they should expect in terms of a time frame for the process in their case. And the specific therapeutic approach that she took for the victim that we began communicating about helped that victim articulate her trauma in a way she had not been able to find before, and in a way that helped me paint the case for a jury really effectively. So I gained a valuable partner also in keeping this victim informed, and in a process that ultimately went on for more than 2 years, I have no doubt that that was a critically important factor in keeping that victim engaged in the process for so long. So where do we start with all of this? We know that we can all meaningfully contribute to making the criminal justice system more victim-centered and trauma-informed, but how to do it may seem like a sort of staggering amount of work and networking. But a starting point might be exploring memorandums of understanding, which I'll refer to as MOUs. Those are basically just agreements between multidisciplinary groups of agencies and organizations towards a common goal, like addressing sexual assault in your community. If you're part of a SART, a sexual assault response team in your community, you should have an MOU. If you're part of a team that does not, you should really consider entering into one. It's a good idea for community-based advocacy groups as well, like rape crisis centers. So there's a few examples that may serve as starting points for you if you're interested in taking this on or re-examining what you already have in your community. The Department of Justice Office for Victims of Crime has some examples on their website. They are specific to SART, sexual assault response teams, but you can pull from them some general inspiration. And then the White House Task Force to Protect Students from Sexual Assault also has a sample MOU on their website. Theirs is specific to building a partnership between campuses and local law enforcement to address sexual assault, which may pertain to exactly what you're looking for. But if not, these are still examples from which you can craft whatever works for you, your organization, your agencies, and most importantly, what works for your individual community. So there are benefits to having sort of a formalized MOU. A few thoughts of what the benefits are. It's a guiding document for everyone involved. It gives everyone a clear sense of their own duties and the duties of everyone else who's entered into this agreement, this team, so to speak. So it gives accountability. And through the process of developing these teams, this multidisciplinary approach, the process alone will identify certain individuals in each organization, each agency, that can be a liaison who can keep open lines of communication amongst all of the partners, which is an important part in actually carrying out this MOU. So some tips for creating one. Make sure that you incorporate a responsibility or responsibilities of each agency and organization to do cross-training, so that each organization in this quote-unquote team has a responsibility to train everyone else on what it is that they do, what role they fill, and really importantly, what the limitations to their role are. You should incorporate procedures for releasing information between participants and these multidisciplinary teams or arrangements. I'll touch upon privacy in just a moment, but we really just don't have the time to explore privacy and confidentiality today. but you should be aware that this should be a robust conversation if you're entering into an MOU, that everyone understands everyone else's obligations with respect to privacy and confidentiality of sexual assault victims. You should designate point people from each agency or organization for ease of communication. And leave your ego behind. Dump any mentality that anyone has a particular turf and just start from scratch. It's developing who should fill and who's best to fill each role, and that may mean that people serve overlapping roles. And don't just stop at signing a piece of paper with no follow-through. Hold team meetings, measure progress, hear others' concerns, adapt this MOU. It should be a living document. Adapt it as necessary so that it works for everybody involved, all of the disciplines and professions involved, but also so that it continues to work for your specific community. So as you follow through and have these meetings and measuring progress and making this an evolving relationship, be aware of what you can and can't do, and be aware of any biases that either you see bringing to the table or others bringing to the table. As your multidisciplinary team works out its kinks, admit mistakes, take advantage of those teachable moments so that it's just an ever-evolving process, because it will only improve the system for not only all of you that are involved, but also for the victims and the accused. So as I said, I'll touch upon the issue of privacy, and there's really not time to review the intricacies of confidentiality and privacy, but every professional, no matter your discipline, should be aware of your obligations to clients, patients, victims, survivors in your jurisdiction. You must also be aware of your own organization or agency's policies about confidentiality. If you aren't sure, go ask when we're done. So some quick highlights. When information is confidential or privileged, that confidentiality or privilege is owned by the victim and can only be waived by the victim, except in the limited circumstances where a court can override that. So I encourage you, when you brush up or learn for the first time the policies and laws that are applicable to you in this area, learn about waivers as well, and what it means to waive confidentiality and privilege and how that can be done. So as I said, confidentiality and privilege should be a robust conversation within multidisciplinary teams, but even in less formal multidisciplinary collaboration. So even in formal efforts like sexual assault response teams, there will be information that one professional cannot share with other members of the team, even though you have that arrangement, absent some explicit waiver from the victim. So everyone has to be clear on what those lines are. You, regardless of your discipline, especially the advocates, should have clear resources and notices for your clients explaining confidentiality and privilege, how to waive it and what the limitations are, and give them a clear manner to waive the confidentiality and privilege if they wish to. And keep in mind that victims, clients, patients, they can execute limited waivers. So for example, maybe you're a medical provider and a patient wishes to waive their privilege to allow you to communicate with the prosecutor about their mental health diagnosis and medication regimen, which may be pertinent to the case. But that patient has also expressed that they don't wish to waive their privilege regarding their HIV status. You have to give them a mechanism to limit their waiver of privilege. I'll also just take a moment while we're on this subject to make you aware or remind you that what the implications are for waiving this confidentiality or privilege. prosecutors have serious obligations to turn over information that's in their possession to defense attorneys. Prosecutors are often presumed to be in control of information that's possessed by law enforcement. A meaningful waiver by a victim of their confidentiality and privilege really only happens in an informed manner if the victim understands that the medical, mental health information that they're allowing you to release to prosecutors may in turn be turned over to the defendant's attorney. That shouldn't automatically foreclose releasing the information to prosecutors, but it should be a balance, and the information that advocates, medical professionals, and mental health professionals have can at times be really invaluable evidence to helping prosecutors make their case stronger and move the justice system along in a victim-centered and trauma-informed way. So it's a balance, but the point is that a victim has to be part of that balance, and the waiver has to be an informed waiver, and it's really only going to be informed if they understand the limitations. So I'll give you an example from my experience as a prosecutor of when privileged or confidential information is waived and can really enhance the case, but also highlight some of the kinks we had to work around. So a sexual assault case in which I prosecuted, the victim's therapist contacted me. She had permission from the victim to contact me, and she called to tell me first in our initial conversation that the victim's greatest fear in continuing with the criminal justice process was testifying in the same physical space as her perpetrator, and that the therapist informed the victim by the time of our call that I had the power to let the victim testify by closed-circuit television, which simply means there is a live feed television between the courtroom and another space in the courthouse so that there's still live testimony. The defendant's rights to confrontation are not impacted, but the victim doesn't have to sit in the same physical space as the defendant as they testify. So in the jurisdiction that I practiced, there was a mechanism to allow victims to testify in this manner, but the only way to do that was to file a motion, hold a hearing, and leave the decision ultimately up to a judge. But the therapist had already promised the victim that I had the power to make this happen. So automatically, me having to deliver the news to this victim that I didn't necessarily have the power, but I could make the effort of filing the motion and holding the hearing, really did have a negative impact on the rapport that I had been building with this victim over a significant period of time. But after working out that kink, we did file that motion and hold that hearing, but in order to do that, it meant that the victim had to waive her confidentiality to all of her therapy records for 2 years, and those all became discoverable by the defense attorney, meaning that I had to turn them over to the defense attorney. And that exposed information that the defendant otherwise would not have had access to, that would have remained private. Such very private aspects of the victim's suffering, like her suicide attempts and communication with family members who were siding with the defendant, and her feelings about that. So it was a balance, and we involved the victim in that conversation, obviously, and ultimately her decision was that waiving that privilege and turning those records over to the defendant was worth the potential gain of her not having to testify in the same physical space as her perpetrator. And so we did that, and ultimately we got the ruling we were looking for at the hearing after days of testimony related to her treatment and the harm that she was suffering after the sexual abuse. But because it was essentially a preview of the evidence that was to come at trial, it compelled a plea. And so ultimately, the defendant pled guilty to a significant amount of jail time and to a plea that was acceptable to both me and the victim. So it resolved itself very well, even though we started off a little bit bumpy. But had there been a trial, what I learned from this process and working so closely with her treating mental health provider there were manifestations of her trauma that I myself, because I'm not a mental health professional, I wouldn't have recognized as really intricately related to her victimization. And really, had I had to go to trial in this case, helped me frame the sexual assault in a way that I wouldn't have otherwise seen to do. So although it was a positive outcome, one takeaway that I will harp on is don't make promises. Rapport building is an important part of the job that each of us do, no matter the profession we work in, when we're working with victims of sexual assault. So having to explain to that victim that I couldn't come through on this thing she was clinging to from the moment her therapist said I had the power to do it really did impact a rapport in a way that I had to work fast. Okay, so we've talked about the ways each of us can meaningfully contribute to making the criminal justice system more victim-centered and trauma-informed, at the same time not disrupting any of the protections that are afforded to defendants. So just take a moment for yourself to envision what this looks like for you and your community. Who can contribute that's not already contributing or that's not being given sort of an opportunity to offer what it is that they have to the criminal justice system. And then let's just draw some information from, some inspiration from two existing models. So child advocacy centers, or CACs. The first CAC opened in the mid-1980s, and now in the United States there are almost 600 of these facilities or partnerships. And they consist of multidisciplinary teams, usually made up of police, prosecution, child protective service investigators, medical providers, mental health providers, victim advocates, forensic interviewers, all with the idea of bringing the system or systems to the child instead of bringing the child to various systems. And the goals primarily are reduce the number of interviews that children who've been the victim of sexual assault, physical assault, really any victimization, reduce the number of interviews that they have to undergo, how many times they have to tell that narrative. To create a more comfortable environment for children to disclose these really traumatic events and to meet all the victims' needs. So the multidisciplinary teams at CACs generally are able to provide greater planning ahead of time before the interview or the casework with a child begins within the team. They, by doing this planning, these teams can identify who in the team is best suited to interview this particular individual child. Case reviews allow for opportunities to refine the planning process, to share new information from research within your own disciplines, your own expertise, engage in team problem solving, to come together to refer a child for additional services outside of the CAC within the community. So in terms of measuring the success of this model, the National Children's Alliance is a national association and an accrediting body for CACs throughout the country. So they've surveyed caregivers of children who were seen at child advocacy centers and surveyed members of the multidisciplinary teams within CACs. So amongst the surveys of caregivers of the children seen at CACs, over 98% agreed that their child felt safe at the CAC. 95% felt that the CAC enabled them to support their child, And in my opinion, that's likely to translate to greater participation in and greater satisfaction with the criminal justice process. Amongst the surveys of the team members, 98% reported that they felt children benefited from the collaboration, and they also felt that the model fostered collaboration. And one particular study that I found looked at communities with CACs, found that those communities had greater law enforcement involvement in child sexual abuse investigations, more evidence of coordinated investigations, better child access to medical exams, more referrals for child mental health treatment, and greater caregiver satisfaction with the investigation process. So again, in my opinion, these will have the derivative effect of more thorough investigation and evidence gathering because victims will be more comfortable sharing the details that enable law enforcement and prosecution to gather evidence and identify avenues for where they can get that evidence. And continued participation in the criminal justice system is obviously a key component to prosecutors bringing cases through the entirety of the process. And the other inspiration from an existing model we can draw from is sexual assault response teams, which I've referenced a few times today. The core members of a SART typically include victim advocates, forensic or medical personnel like the SAFEs or SANES I spoke about earlier, police, and prosecutors. And the collaboration happens in a few ways. Policy adaptation and review by drafting and reviewing guidelines for the team and the community that are aimed at ensuring that every victim and survivor gets the appropriate response. Cross-disciplinary trainings so that each partner has a sense of what every other partner does and what role everyone serves, the limitations of those roles. Case reviews so that these teams review individual cases so that they can assess what went well, what needs to be improved upon, and then overall program evaluation. So this is continued data collection and analysis so that the team can periodically evaluate their overall effectiveness and then determine broad improvements to their approach. The most effective model will vary. It should reflect the community that the team serves. Currently, there are teams throughout the United States, and they vary in how they implement each of the components that I spoke about. They vary in terms of the frequency of training, the case reviews, evaluation fluctuates. So it's difficult to measure the success because there's such varied models. But one study surveyed SART members and found that the programs that implemented the 4 components I spoke about on a more regular and regimented basis, as opposed to those teams that were structured more informally, were believed to be more effective and had a more positive effect for clients, according to the respondents in that study. Another study found that when legal and medical systems coordinated with rape crisis centers so that advocates could support victims during the police report, the making of a police report, or the medical forensic exam, the victims rated those interactions more favorably. So, we started today's presentation reminding ourselves that we know sexual assault is vastly underreported, and of those reported, few are prosecuted and result in a conviction throughout the entire process. And we noted that one reason is victim attrition during the criminal justice process. So these studies and another study of survivors who did participate in the criminal justice system despite a lengthy process said that a positive experience with a sexual assault nurse examiner, advocate, or police in which they felt respected at the outset contributed to their continued cooperation with the prosecution, even when that was a lengthy process. So we can deduce from all of this that effectively collaborating so that everyone approaches and responds to sexual assault victims in a trauma-informed way will directly impact the quality of the investigations, the ability of law enforcement and prosecution to bring these charges throughout all the stages of a criminal justice process. So in my experience in the jurisdiction in which I was a sexual assault prosecutor, we had both a child advocacy center and a SART in a formalized structure. So there was open communication, there was mutual respect and trust, and that really manifested in so many ways and really enhanced so many of the cases that I prosecuted. So that open line of communication and the mutual respect for each other's roles gave me the ability to call for expertise, another discipline in the team. Whether that was informally picking up the phone and calling the social worker at the CAC for advice or general information about a particular condition or particular advice for communicating with the victim, or calling them as an expert witness, I was better able to meet victims' needs, better able to gather and frame the evidence that I had, and just overall better find better results and achieve justice both faster and in a way that really more reflected a victim-centered approach. But what I will say is that we did lack a relationship with community-based advocacy groups. So because we didn't have these well-developed relationships with community advocacy groups outside of the CAC and the SART, when they did reach out, they often lacked the information about the criminal justice process and local practice and had already misconveyed information to their clients, victims, similar to the story I told you about the therapist who had made a promise I couldn't necessarily keep. So again, this negatively impacted sometimes the rapport that we at the district attorney's office had with our victims or witnesses. It also at times had the effect of driving a wedge immediately between the prosecutors and the community-based advocates who were really reaching out to be better informed or to advocate for their clients. And had we had that better communication and information sharing, then we may have been able to impact a victim's decision not to drop out of the process and to continue participating in the criminal justice system. So I think that by not having better developed relationships with some other community advocacy groups, what we missed were opportunities to have a partner in keeping the victim informed of each of the stages of the case. I know that I myself, as many prosecutors throughout the country, had a heavy caseload. And as I said, sometimes it's hard to convert the language of the criminal justice system when you're in, sort of deep within it, into a language that's digestible for the victims who are traumatized. So I think we missed opportunities to have partners to do that, and missed opportunities to have a partner in helping make sure the victim truly understood the information that I was relaying. And again, I think that would have translated in some instances to a victim staying on board with the process. So I'll move on and talk about how another potential benefit of having a multidisciplinary approach to the criminal justice system in your jurisdiction. In December 2015, the Department of Justice issued a guidance which was aimed at identifying and eliminating gender bias in the policing of gender-based violence, so domestic violence and sexual assault cases. So what does gender bias mean as a starting point? Well, they defined gender bias as implicit or explicit implicit, conscious or unconscious discrimination that leads law enforcement to giving less protection to certain victims based on a bias or stereotype. So if gender bias influences law enforcement's initial response to a sexual assault, it will very likely have a trickling down impact on the investigation, whether and to what extent charges are filed, and then any resulting prosecution. How does this happen? Well, bias might impact whether law enforcement finds the victim credible at their initial interaction with the victim. So that can manifest in mischaracterized or underclassified reports, reports that are deemed unfounded without any follow-up investigation, lackluster investigations that then don't give prosecution sufficient evidence to bring charges or to prove charges beyond a reasonable doubt at trial, which is the burden that they have to be able to meet in every single criminal case. So the recommendations in the Department of Justice's guidance include thorough investigations of all sexual assault complaints and referring victims to appropriate services. Those are just two of their recommendations. So in my view, a multidisciplinary approach will help accomplish this. It would make it easier for law enforcement to refer victims to appropriate services, because having relationships with the community service providers locally will help law enforcement better identify immediately what service a victim might need and who in the community provides that service, so that they can take this trauma-informed and victim-centered approach by helping the victim meet their other needs, and that will help them build credibility with the victim and really foster a situation where the victim may feel more comfortable disclosing all of the details of a sexual assault that are so critical to law enforcement being able to investigate. And other disciplines working with the victim may identify aspects of a crime, avenues for investigation, or pathways for a prosecution that weren't immediately apparent to law enforcement. That two eyes are better than one approach. Or you may identify a bias or a stereotype that's permeating the response in your jurisdiction. So if a relationship exists, then the disciplines who aren't ingrained in the criminal justice system, if you have a relationship with law enforcement, you may feel more confident to reach out, to know that you'll be heard because you have this relationship. There's credibility and trust amongst the different professionals. And you may be able to bring to light some implicit, hopefully not explicit, bias that's permeating the investigation or the case. So a recommendation would be to weave the Department of Justice's recommendations into memorandums of understanding that you enter into, so that they just become practice in your community among everyone. Okay, so that's it for today's presentation. As I mentioned, we're currently developing this online training and supplemental guide, which we're calling Helping Sexual Assault Victims Navigate the Criminal Justice System. It is under development, so in the meantime, we are available to provide technical assistance. You can contact me at the information on the screen now at any time, and we'll try to provide you assistance, additional information that will help you in your practice and your work. And we thank you all very much for the work that you do. We have about 10 minutes, so I'm just going to mute myself for a moment, see if we have any questions that we can address in the remaining time. So just bear with us. Okay, so I'm just going to address one specific question. Someone was looking for us to go back to the samples of the MOUs. So here are the two websites you can check for the sample MOUs. If you want to, if you're looking for a link to these specific ones I referenced, you can provide your email address in the Q&A box with that request, and I'm happy to email you the specific links that I found to both. We're getting a couple questions about the PowerPoint itself. If you look in the box, which I think appears underneath the PowerPoint on your screen, you can download the PowerPoint slides. If for some reason you're unable to do that and you want to provide your email address, if you're unable to download it, you can email me at this contact information, and I'm happy to provide these slides. If we got a couple questions about a certificate of completion, we don't have one prepared. If you need one for your agency, feel free again to contact me. I'll forward it on to our program associate, who's happy to make one up for you. And we're going to a couple other questions. Just bear with us for one moment. We'll see if we have time to answer these. Okay, it looks like we don't have any other general questions to address related to the presentation today. So we'll wrap it up with that. Thank you very much for attending the webinar and for your work. There will be an email forthcoming with a link to the recording and the PowerPoint presentation as well if you didn't get a chance or you're having trouble downloading it. Thanks very much.